Hi, I'm Jon Velie, CEO of OnlineVisas, lead counsel of Velie Law Firm, and welcome to How to Win H-1B Visas Following Trump's Executive Order 2020. We will give a little bit of time for some folks to get here. Looks like we have a few attendees have already showed up. What we'll do is, if you have questions, please put them in the questions section. I'll try to get to them. We're going to have a lot of information to cover today. We have about 38 slides. There's a lot of things that have happened since March. And so H-1Bs are going to be totally different this year than from last year. And we're past the cap season. So we're going to talk about what's left after the presidential proclamation came down and what we expect to go forward. So I'll give us a few more minutes or a minute or so, and then we'll start digging in. So again, if you need to get up and get a cup of coffee, take a break down the hall, go ahead and do that, and we'll start here shortly. So hope everyone's having a good day today, and we will have a recording of this if you want to see it later, and we'll have some additional ability to see this webinar later as well. Also, feel welcome to go to OnlineVisas.com and set up a strategy session if you want to talk about this, or email me any of your questions you may have, and I'll try to get them back to anybody that asks questions. I'll answer all of the questions you ask to everybody that asks them. My email address is Jon, Jon, at VelieLaw.com. That's V as in Victor, ELIELAW.com. All right, well, let's get going. So we got a lot of stuff to cover today. Very, very heavy. We've got about 6 major things that have happened in immigration since March, and we're going to dig into them. If you've seen some of the videos we've had on YouTube, it goes into this as well. This will be more in depth, but if you want to check out that, we have a bit of a teaser one that is about 10 minutes long, and then we have an hour-long video as well. Feel free to check any of those out. So let's get going. Let's see here. I think this is going. Pardon me, guys. Oh, there we go. Okay, so I'm Jon Velie. I'm an immigration attorney. I'm from Velie Law Firm and OnlineVisas, the CEO of that company. Here's a couple of my kind of accolades, I guess. If you want to know more information, again, go to OnlineVisas.com or just drop us an email at Jon@VelieLaw, VelieLaw.com. Our agenda today, we're going to try to knock through this pretty quickly, is going to be over a number of different things that have all happened really since March. One's the executive order of June 22nd, 2020. That has also been called Trump's immigration ban, dealing with the non-immigrant visas, in particular the H-1B. They're the ITServe Alliance case that came down March 20th, and the other federal law cases that have, the other federal law cases that have come down that have really shaped how to do H-1Bs this year. There's the memo of June 17th, 2020. There's winning arguments and supporting case law. We'll tell you how to do that. There are some special circumstances for COVID-19. There are public charge issues this year, and then we'll open it up for questions and answers after that. Again, you can put your questions in the box there, and I'll try to get to them if we can. All right, so going forward, the Trump executive order of June 22nd, 2020 was a proclamation suspending entry of aliens who present a risk to the U.S. labor market following the coronavirus outbreak. That proclamation made a number of findings in February and April that 17 million jobs were lost in U.S. industries tied to the H-2B, 20 million for industries tied to the H-1B, and the May unemployment rate for Americans who compete with certain J non-immigrant visa applications, particularly high, 29.9% for 16 to 19-year-olds and 23% for 20 to 24-year-olds. Find that pretty interesting. It's sort of like make the facts meet your mission. But what we also saw is in the tech industry, we saw a drop in unemployment from 3% to 2.5% during the coronavirus pandemic. Yet that industry has been punished by this proclamation. But there's some meat left on the bone, and we're going to talk about how to go after it. So the suspension has been the H-1B and or H-2B visas, the J visa for some of them, the interns, trainees, teachers, camp counselors, au pairs, summer work travel program, and any alien accompanying to join them. The L visa, of course, any aliens accompanying either of them. So this only applies to foreign nationals outside the United States. Let me repeat that, only for foreign nationals outside the United States, meaning if you're inside the United States, you can still apply for those visas, including the H-1B. It does not apply to those who have, this thing is just skipping on me, sorry. That does not apply to those who have a valid visa, meaning that if you've been approved and you've been to the consulate and it has been stamped into your passport, you can enter. However, if you've been approved and cannot get into the consulate, then you're not going to get in under this visa unless you meet one of the exceptions. The other thing is if you have a travel document, so say you're on an H-1B, you got a pending green card, an EAD card that has the advanced parole on it, you can get in. Also, Canadian citizens can get in on their passports only, so those can still come in. Now, here's the exceptions. Critical to defense, law enforcement, diplomacy, and national security of the United States, nurses and physicians working in hospitals related to COVID-19, medical researchers for COVID-19, the national interest, temporary labor to the U.S. food supply chain, and if you're necessary to facilitate the immediate and continued economic recovery of the United States. All right, there will be a waiver process for those above, but it has not yet been defined, and we learned lately they will not make that public. So if you think you fit any of these criteria and you want to talk about it, go to OnlineVisas.com, set up a strategy session, or drop me an email as we talked at john@velielaw.com, and we can talk about this. These will be won at the consulate level. What that means is you will file your H-1B anyway, as you always would have. You will then get your approval, and after you get your approval, set up a DS-160, which is your online form to set up an appointment. At that appointment, you'll then go in and win this case at that point. This is where the lawyers come in to make those arguments for you. We can talk about how to do that. There are some things that come to top of mind. National interest, probably going to be one a lot like the national interest waiver under the EP2. Nurses and physicians working in related to COVID-19, you're going to have to show some sort of relationship, a letter or a contract to a hospital and have COVID-19 relationship or be tied to that. I think that's probably a pretty easy fit if you can get there, but it's going to require some specific drafting. Medical researchers, I think you could probably extend this into anybody that's doing anything related to COVID-19. That's my opinion. And then the necessary to facilitate the immediate and continued economic recovery. That's really interesting. I think what this is to give an entree to negotiation with this administration. So companies that are doing very well but need this will probably have a good chance. I think you're really going to have to show what you do and how it's worked. I've seen a couple of cases I think would make good cases for that, but nobody has experience on that right now. So it's really going to be how do you go about that and using maybe experts, data. Don't just write letters. That's really what we have about immigration right now. Letters are not very valuable. You really need to have some primary evidence related to it. Let's move on. All right, so you can still file an H-1B if the exceptions we just discussed, amending or extending from a previous H-1B. I cannot say that enough. If you are on an H-1B, even if you're with a different company, you can still amend or extend that. And you may remember that the H-1B, my God, this jumps. The H-1B allows you to start working for the new employer if it's substantially the same employment that you had from the previous employer at the receipt of your at the receipt from USCIS and not at full approval. Now, there's some risk in there, and so some people don't want to do that. If you're denied, then you've been out of status since you left that previous job. If that's more than 180 days, that can be you can end up barred. So premium processing isn't a bad idea, or waiting till you get it. Changing visas from a cap exempt H-1B to from another visa. All right. So why I say cap exempt H-1B? H-1Bs are capped right now, so only universities and institutions that are related to universities and have to be related very, very tightly, same regents, same ownership, that sort of thing. University hospitals are an example of that. Some other things can do too. Basically, they have to be nonprofits. Changing to a status of an H-1B after returning home for a year and having held one within 3 years but being in the United States, or if you're on a visitor visa, you've had a visa, an H-1B within 3 years, but you've been home for a year, that's one that you could do. It does not list the H-1B one from Chile and Singapore. We think that's important. We think the reason that that's like that is because there's a treaty within Chile and Singapore. And that's why the other related visas, like the E3 from Australia, which is essentially an H-1B, is still possible to apply for. And any of the E visas, although they're nothing like the H-1B, the E1 or E2 are still okay. That's because of treaties. Same with NAFTA. That's the TN visa for Mexicans and Canadians, not the H-1B, but it's not listed in there. And we think it's because of the treaties that they were not included, even though they're professionals and in the same demographic. All right, so ITServe versus Cissna. This is a case that came back in March 2020, where it held that the 2010 and 2017 memorandums and the USCIS application of the defensor case to deny a number of H-1B visas, particularly those, this is crazy, I'm sorry, particularly those that petitioned for employees to be placed at third-party locations, was in violation of the regulations. All right, we've thought this for a while. The USCIS was going way too far in what they're expecting out of the staffing companies and the companies that are hiring the staffers, right? So we saw up to 60% denials in some companies that were the vendor level, and even a higher percentage at those at the staffing companies. This was a huge win by ITServe, which is an association of mostly staffing companies, over 1,000 of them spread around the United States, did an excellent job of doing that. So after that case came down, there was still a memorandum the USCIS was using actually 2010 and 2017 memorandum. So they settled the case with the government and withdrew that, and they issued a new memorandum in June 17th. We're going to go over that. While the ITServe case language is very strong, stating the H-1B visas where workers are sent to third-party locations do not need to provide itineraries and a chain of contracts for the duration of the H-1B visa. The memo is interesting in how it applies its applications of the case settlement and agreement. Okay, I cannot say this enough. If you think it's going to be easy to get an H-1B just because the USCIS lost a lawsuit and settled it, you're in for a tough surprise. You just by looking at what the case said in its language and what the memorandum says is you can just tell that they still will deny cases even on these issues. So what it's really about is how do you brief these cases? I'm going to tell you what our strategies are and how we do that. And at the end, I'm going to tell you how we go about it. And if you'd like us to help you with your situation, we'll do that. We can analyze how you do your H-1B visas. We can look at your RFEs or denials. We can do an audit of your system. We can show you what we do in ours. But we're going to go through and show you how we think about those things. What are the strategies that we are using, and what is still left in what order to win an H-1B visa because of these wins, and what do you still need to fight hard on, because there's a number of those issues left there. All right, here we go. Let's explore that. Okay, this is the memo. What we're going to do is I'm going to tell you what the memo question is, what the memo answer is, and then we're going to go through kind of what does that mean and some thoughts on it. Okay, so the memo question: should an officer consider an H-1B petitioner and an H-1B beneficiary to have an employee-employer relationship if they meet if they meet only one of the higher pay fire supervisor or otherwise control the work of factors under 8 CFR 214H42? Well, the answer is yes, right? So the officer should apply the existing regulatory definition in assessing whether they have that relationship. They should consider whether they've established it meets at least one of the higher pay fire supervisor or otherwise control the work of factors with respect to the beneficiary. H-1B petitioners are required to submit an LCA and a copy of any written contracts between the petitioner and the beneficiary, or a summary of the terms of the oral agreement if written contract does not exist. Depending on the content of such documentation, it may establish the employer-employee relationship. The officer may not apply the prior rescinded guidance. What they were doing before is they're making you meet more than one of them. They're sometimes discounting one of them or making you meet all of them, right? So that's not the case anymore. That was the essence of what happened, okay? But see there, you still have to prove it, right? You can't just say it. All right, so what does it mean? Well, the contract language must be clear to indicate any of the 4 factors. This information can be included in a formal contract, an employment agreement, the letter of support from the employer, or another co-signed document between the petitioner and the beneficiary. All right, what did the case law say? Okay, so they said here's how they interpret it. The case law says the ITC court addressed USCIS repeated denials of visa petitions for failure to demonstrate a valid employer-employee relationship. The court held that it was sufficient to establish the relationship by meeting the plain language that specifies the employer may hire, pay, fire, supervise, or otherwise control the work of employees. ITServe reasoned that additional requirement of providing day-to-day assignments to show the requisite control employer was erroneous, and that meeting any of the 4 criteria under the regulations are sufficient to demonstrate employer-employee relationship, including otherwise control. So what does that mean to otherwise control? How does this help our clients? So otherwise control is going to be in the Darden case, and it's going to be in the language that you show how to do that. What we suggest is in your organic documents that you have that information, right? It can be in your employee handbook, it can be in the contracts you have, it can be in the agreements you have with vendors or third parties. Memo question 2, under the employee-employer relationship, must the H-1B petitioner establish the employment exists at the time of filing? So it must. So the petitioner is required to attest under penalty of perjury on the H-1B petition in LCA that all the information contained in the petition and supporting documents is complete, true, and correct. Okay, so what are they looking for here? Well, a number of companies used to file H-1Bs at the cap, right? It used to be April 1st. It's now you got to register a month earlier than that. But at that time, they would say, okay, I'm going to file 50 H-1B petitions because by October, I'll get that work. This is what they're after. This is really why they started all of this, because they didn't think there were really jobs there. Okay, so what they're doing right now is they're doing site investigations, site visits, I should say. They're rating and they're doing things like that. And what they'll do is they'll go ask your clients, if you're an employer, about this situation. When did you get this job? Show us this sort of stuff. So we really state, don't do that, right? Know what your work is ahead of time. Get some clients to agree to hire your people and get it in writing. That's your best protection. Memo question: should an officer request a chain of contracts or legal agreements between the H-1B petitioner and third parties, including the ultimate end client and any intermediate vendors, to assess the employer-employee relationship or non-speculative employment and especially occupation, which is work availability? So again, it's jumping on me. Memo answer: in support of the petition, an H-1B petitioner is not required by existing regulations to submit contracts or legal agreements between the petitioner and third parties. However, danger question, right? Danger point. That's why I put it in red. The petitioner must demonstrate eligibility for the benefit sought. In assessing whether employer and beneficiary have or will have an employer-employee relationship, the officer may consider any evidence provided by the petitioner, including chain of contracts or legal agreements between the petitioner and third parties. Further, if a petitioner provides contracts or legal agreements, the officer is not precluded from evaluating that evidence in the adjudication of other eligibility criteria. Look what they did here. Look what they did. Okay, you don't have to do it, but if you do it, we're going to look at it. Okay, so what does that mean? Let's see if we can talk about this next. Okay, you don't have to provide it, but if you do, they can evaluate it and use it against you, or in other criteria, right? So inconsistent. So how would that work? Inconsistent job titles in the evidence could mean it is not a specialty occupation. Inconsistent dates, job duties. Job duties, uncertainty about who the employer is, if third-party documents seem to indicate employment conditions are present for the third party, and inconsistent work locations. We see this a lot when we inherit cases at the RFE stage. When people send us their RFEs, many times we will find that there is an LCA that says one location or one type of job. Then there's an employment letter that wants to do the lowest LCA, right? Which might connect with the LCA, but then we have a vendor letter that calls the job something else, which may have a higher pay, and then a third party letter that may call them something else. Now you can have different job titles, right? If the job duties are the same, but if they find inconsistencies, I'll guarantee you they will find a way to at least issue an RFE and many times deny. They're not going to give you a pass on this stuff. This is what it's really there. So if our kind of thought is on this is if you have these documents and they prove it out without inconsistency, you got to look at all of it, then put it in. If they don't put it in. And that is a case-by-case analysis for sure. Okay, next memo question. May an officer deny a petition for an H-1B on the basis that the petitioner, while having identified and described the nature of the specialty occupation, has not specified the beneficiary's day-to-day assignments. Okay, which should be no, right? But it says an officer should deny a petition when the beneficiary has not established the beneficiary will work in a specialty occupation. That is a classic example of giving an answer that wasn't the question asked. So they said if the day-to-day assignments, and they said if it's not a specialty occupation. So what does that mean, right? So what they're going to do is determine it's not a specialty occupation if you haven't proven that you really did it. So while the petitioner is not required to identify and document the specific day-to-day assignments, the petitioner must meet all the statutory and regulatory requirements, excluding the itinerary requirement, which is a day-to-day assignment, because of that. Okay, so if the officer finds petitioner is not established by the preponderance of the evidence, statute or regulatory eligibility for the classification, the officer should articulate the basis denying the H-1B. The officer should not apply the rescinded guidance. Okay, so they're saying we're going to deny it if you don't give it to us on the basis that it doesn't meet a specialty occupation because you haven't proved what you're supposed to do, even though you don't have to give day-to-day assignments, right? That's what they're saying. So how do we deal with it? Okay, they're using the lack of specificity in the duties to determine the petitioner has not proven the job is what they say it is. All right, does this make sense? All right, if it doesn't, please contact me and we'll go into this about your case in particular. But how to handle this is you describe in detail what the duties are and include evidence that supports it to support the work product, marketing materials, milestones, project plans. It's important to distinguish between job duties and the type of information typically provided in a job posting. Job duties should be describing day-to-day activities of the worker, not listing the responsibilities, describing outcome goals, using vague terms like manage or oversee without unpacking what actions will be taken to perform those duties. Okay, so the key here, how to win and what to do about this, right, is you can talk about what your people are going to do in non-vague, but not precisely specific. So what they wanted you to do a year ago was to say, where is your employee going to be and what's he going to be working or what is she going to be working on specifically for the next 3 years? That's ridiculous. You don't have to do that, but you should go into the detail of what they will do precisely. You can talk about the language. If it's a techie, what kind of software packages are they using? What kind of stacks are they working on? Are they doing front end? Are they doing back end? Are they doing networking? Are they accountants? Are they architects? Are they lawyers? What kind of specifics are they doing? If they're lawyers, are they litigators? Are they contract attorneys? All these sort of things. You want to dig into that. They will come back to you, I think, saying it's too vague, and that's where the heart of these cases are going to be this year. All right, so non-speculative occupations. Memo question, should an officer require evidence of day-to-day assignments to establish the availability of a specialty occupation work? The officer should review the position as described by the H-1B petitioner to determine if the petitioner has met the burden of proof to establish the beneficiary will be employed in a specialty occupation. While the evidence of specific day-to-day assignments is not required to establish the position is in a specialty occupation, the petitioner may choose to provide such evidence. All right, you don't have to do it, but if you do, it'd be nice. It's kind of like when the police ask somebody that comes into an investigation, you know, they tell you you have the right to remain silent, but then they still keep asking you questions, right? So this is why you need an attorney, right? It's really, really important what you say and what you don't say. What's in there and what's not in there. That's what this is all about, right? They are lulling us to sleep by saying you don't have to give it, but if you don't do it, we don't know if it's going to prove it. Well, what are they really saying, right? That's what lawyers do. They tell you what that means. So it means an employment letter or contract can be sufficient to describe the job. You don't need the itinerary, right? What we suggest is be as specific as you can without having to show where that person's going to be every day for the next 3 years. And I think, you know, if you're too specific, then you can contradict yourself. Or if we're going to say he's only going to be working or she's only going to be working on one job and you intend them to work on 30, don't do that. All right. They'll come get you at the next amendment of that when you work 30 jobs instead of one. So you got to, there is an art to this scenario. Okay. So note, the description should be detailed and not vague. It can list examples of projects, right? But not limited to that. We are working on these, but not limited to these, right? It can discuss the company provides its services for numerous clients regularly and expects to onboard other clients and projects through the term of the beneficiary's employment. This is what they didn't want you to do a year ago. This is what they still don't want you to do, but it's okay to do it, right? I'm a lawyer. I hire people. I get clients every day that I don't know who they are until we get them. I cannot possibly say that the people that work in my office, whether lawyers or case managers or whoever, are only going to work on this person's case for the next 3 years. That's what USCIS tried to trap, and that's what's not required. But I can tell them what kind of things they're going to do, an example of who they worked on in the past, and what we expect them to work on in the future. Here's some clients that we have. We expect to have long-term. Here's some other types that we're going after, and those are some ways to approach this that I think would be successful this year. All right, next one. Memo question: may an officer deny a petitioner for an H-1B non-immigrant classification on the basis that the petitioner, while having identified and described the nature of the specialty occupation, has not specified the day-to-day assignments? An officer should deny the petitioner. Okay, so that's a real good question, right? But again, not the answer to that question. An officer should deny a petition when the beneficiary is not established to be working in specialty occupation. This is their go-to. Okay, see what they're doing here? There's a question saying, what if we don't put in the day-to-day assignments in this role? And then they say, without answering that question, we're going to deny if it's not a specialty occupation. We're going to go back to specialty occupation after that. This is what we're saying. This is where the fight's going to be. If you think you can throw something in the way you used to do it in 2016, and they're going to go back to that, you will be wrong. I mark my words right now. While the petitioner is not required to identify and document the beneficiary's specific day-to-day assignments, the petitioner must meet all the statutory and regulatory requirements, excluding the itinerary requirement. Binding court precedent, AAO adopted and precedent decisions. Okay, so we're going to show you kind of what we can do with that, and that is do what we're going to do, support it with the case law. Okay, briefing is critical. If you think you can just go in with a 2-page letter like you used to in the last administration, I think you're going to find a lot of RFEs still. Okay. All right. So what does that mean? Just because you do not have to provide day-to-day assignments doesn't mean you will not be denied if you don't establish the jobs, especially occupation. Be specific in the duties. List examples of clients, types of work out of the stuff we said. Make sure the duties are similar, but not exactly like the OOH, duties for a similar job. OOH is the Occupational Outlook Handbook, all right? And they have their duties under that. Make sure that the duties require knowledge from a degree that's required under the OOH. That's where you go to the tab, how to become one, all right? Don't be afraid to include some technical language like details about complex methodologies employed, technical tools used, and other specifics about the process, provided you describe how they work in layman's terms, right? Like, remember, these are not technical people, so don't throw a bunch of technical language at them, expect them to understand it without giving you an RFE, because they will, right? They are actually proud that for them to say, we don't get what you're talking about, right? That is a real basis of denial. So you have to write it like a layman would think about a technical person's job. We as lawyers are often translators to help that process. Next question: may an officer deny an H-1B extension or change a status request or revoke approval of an H-1B non-immigrant classification if the evidence in the record established the beneficiary was benched or never worked but is still paid? Okay, look at this very long, this isn't even the full answer, right? Not even the full answer, but except in certain limited circumstances, benching is prohibited by law to prevent foreign workers from unfair treatment by their employers. Okay, they're worried about that, right? And ensure that the job opportunities and wages of U.S. workers are not being protected. They put benching in quotes, okay? The failure to work according to the terms and conditions of petition approval may support, among other enforcement actions, revocation, and they go on to that. Guidance concerning benching remains unchanged. Benching's a bad word, okay? That doesn't mean that we're dead if your worker doesn't work the entire time. I'll tell you why. But they're saying lack of work may be a material change. No longer employed in the capacity is a basis for revocation on notice. Being placed in a non-productive status or training for extended period of time, even if paid, may qualify as no longer being employed. All right, they're saying everything they can to say they can still deny you, okay? What's the law really say? Okay, so as we said, this lengthy discussion is to discourage a situation where employees may not be working even if they're paid. Benching is a term that means the process is illegal. However, not all instances of non-work are benching. They list a few examples where it's permissive under the FMLA and or the ADA, pregnancy and sickness, right? But those short periods still may be okay if the worker did not fall under those statutes, okay? The key is never falling under the prevailing wage, all right? That's really key. And it is good practice to keep the employee working on something if possible, okay? But just so you know, so the ITServe court addressed that, and the itineraries indicated a full visa term of uninterrupted work was in opposition to the 1998 ACWIA when Congress anticipated non-working periods during the term of an H-1B and moved to avoid any negative impact on U.S. employees by making foreign workers cheaper to employ. Therefore, the itinerary requirement of INS 1991 regulation as adopted by INS, now enforced by CIS, has been suspended or superseded by statute. Very critical. Okay, now do you go into these things saying we're going to bench this guy, we're going to keep him not working? Don't. Do not do that. If you can keep them employed, that's the best practice for sure. But if something happens, you do not have to just concede the case. You can answer the RFE with this ITServe Alliance language and win this. You can also litigate against it on this basis and go back and litigate if any of this had happened to you in the past. If you've been denied for this or any of these other reasons in the past, you can sue right now. If you want more information on that, contact us at OnlineVisas.com. Set up a strategy session. We can tell you. I can go back and win some old cases. All right. All right. Next memo question. Should an officer continue to apply the itinerary requirement? Well, they say no. All right. They've said no all the way through. That is exactly precisely the language they can't do. So I'm not going to go into that any further. All right. The case law. ITServe strikes down in details an itinerary that are inconsistent with the professional specialty occupation as previously enforced for decades and inconsistent with that regulation. ITServe holds that it is irrational, that is arbitrary and capricious, to impose the requirements of contracts and other corroborated evidence of dates and locations of temporary work assignments for 3 future years. It is, in fact, a total contradiction of the plaintiff's business model of providing temporary IT expertise to U.S. businesses. It would destroy a long-standing business resource without congressional action. All right, staffing companies are not bad guys. Staffing companies are not breaking the law. You can be a staffing company, okay? That's what this case is all about. You just have to do it the right way. Now, knowing that, is immigration held their nose when they settled this thing? Immigration is going to look for other ways to deny your H-1B. Immigration did not get easier. We can tell that by this attack with this proclamation against H-1B visas, which also may not be legal and will also probably be subject to some litigation as well. So be on the lookout. They are not going to take this thing lying down. They're going to come at you, and they're going to come at you hard. All right. But it's all going to be at the specialty occupation deal. All right. Limiting time periods. May an officer limit the validity period of an H-1B petition? Well, they shouldn't, but the USCIS may issue approvals without with validity periods shorter than the time period requesting. However, that decision must be accompanied by a brief explanation, right, is why the validity period has been limited. This includes, but is not limited to, instances which the certified LCA has a validity period of shorter duration. Okay, so they're going to go to the LCA anyway, right? So if your LCA is shorter than 3 years, you're going to get shorter than 3 years. If they want to shorten it for some reason, all they say they have to do is give a brief explanation. They shouldn't do it, but they're going to. So, but the case law says ITServe also invalidated CI's practice of granting visas for less than 3 years. This is one of the easier pieces of litigation they won on, by the way. Again, so if you have short litigation, say you had a couple more years you asked for, you can litigate right now. And there are some groups right now that are litigating these things in mass. So you can get in, and it's pretty inexpensive. And I'm glad to talk to you about it if that's what you want to do. It represents change after decades or past practices on which U.S. employers have come to rely on, which presumably remains in practice for employers in other industries. And therefore, we do not legitimate denials that were arbitrary and capricious and in violation of the APA. Again, short denials have been crushed by ITServe. USCIS is still telling its adjudicators that it can do it. So beware. Specialty occupation. Okay, this is what issues are still there and difficult to do. All right. So sort of hidden in the other categories, it was pretty obvious, right? Must be the OOH. So sort of hidden in the other categories, is this still a very huge issue? That's the specialty occupation issue, right? And so must be an OOH occupation. All right. I say must be. I'm going to tell you a little bit, if it's not, how to go there, but best practices, don't pick a non-specialty occupation. I know they're really jobs, right? I know quality assurance tester and architects are out there, but man, it's much better to be a senior developer than an architect if you want your visa approved. All right, they can still oversee people and those sort of things, but we'll talk about that. If you're in that position, you need to do it, what to do. Okay, but look out for denials or RFEs if not supervised sufficiently, if at a third party. All right, watch out for inconsistent titles at third parties. Watch out for inconsistencies between LCA, employment letter, designation on form. Do not go back to 2016 way of processing. Think this is going to be easier. I just promise you it's not going to be. How to win. Use case law tied to the regulations and clear reading of the language under the OOH. Rely on the duties and how to become one tabs. Those are the tabs under the OOH. You don't know what I'm going to look at, go to the Occupational Outlook Handbook. You'll see what I mean. The duties have to be similar, and it really, a lot of this is going to be on the language around how do you become one, which majors can be there. And there's some really good case law that supports an expansion of what immigration's been doing, but they didn't settle that case. They didn't have a new memo on that one. Okay, so that's really where the fight's going to be this year. All right, so here's some case law for you on a couple of different issues. All right, now Next Gen came out a couple of years ago, in 2017, actually a few years ago now, and they just slammed them. But you know, we found in putting that case out there that they ignored it a lot, right? We saw denials, not on our cases so much, but on looking at other cases when we were helping ITServe Alliance get ready for their lawsuit. And those lawyers, we presented them with a summation of a number of different denials that other companies within that organization had seen. And they literally just spit in the face of Next Gen on some of those deals. So, but that's even affording appropriate deference to the government's interpretation of the statutory and regulatory requirements. This court is allowed to see a rational connection between the evidence indicating that most computer programmers have a bachelor's degree and USCIS's determination that the computer programmers are not normally required to have a bachelor's degree. All right. While general degrees are not permissible for a specialty occupation, federal cases have provided clarifications of USCIS recent decisions to deny cases by interpreting regularization in opposition with text, structure, and history. So that means, look, this is what you're going to see in a lot of these cases, that USCIS doesn't think that most means 51, that they think it's a much higher than that. And we'll see that in one case, they say even 70%. We'll go through that. All right, so here's something that really came down lately. So in March 31st, so a lot of this stuff all happening in March and later during the pandemic, lots and lots of changes this year. All right, so two cases came down, one called Taylor May and one called Info Labs, both in the DC District Court. Really good court from when it comes to doing these types of cases, right? So they said that defendants' practice of avoiding expert opinion and employer evidence. Oh, I'm sorry, that's bar chart. So they entered in it. All right. So in all these cases, the agency determined that the DOL's authoritative source of information about the occupations, right, in the OOH stated that most United States workers have a degree in a specialty occupation, computer science, that was typical for the United States workers to have this degree when working in the field. Notwithstanding the Department of Labor's position, the agency found it was not normal for United States workers doing the job to have a degree in a specialty occupation. He found this reason to be arbitrary and capricious. And we were talking about that. So most, typical, normal, all mean 51%, right? So they were thinking that, you know, if it wasn't absolutely everybody, that it wasn't normal, and that's what they shot down. So look at the language under the OOH, and if you find the language that says most or normal, then you're okay with that. What that means is under the how to become one tab, you look at what degree typically is required by that sort of profession, and that's where you go. All right, so here's some other ones. So 3Q invalidated USCIS interpretation of the degree requirement, and the DC court again in bar chart. This was an issue where an expert came in and said it was needed, and the employer had additional letters, and immigration just ignored it. Right? They like pretended. Maybe you've seen this if you've been doing this any time at all, where immigration just ignores things you put in there and then go that. So they got slammed on their bar chart. All right, so that's good to know. You can use these things to cite them many times in an RFE, but we like to answer our RFEs up front, so if we can do that. So another case that had a lot of things in it was inspection expert, we call IXC versus Cuccinelli. And this was where a quality assurance engineer was able to get a visa. And this is where they relied on ONET statistics to do that. Now, again, USCIS has sort of ignored ONET for OOH. And so, you know, that's what they do. But this one was really weird because they USCIS construed normally to require something more than most, or 70%. Actually put that in writing. They required 70% of the people that do it to be most, right? Well, it's not. So their court held instead to look at the ordinary meeting term. They looked at the Oxford University Press definition under defining as I guess most to be under normal or usual conditions, a usual way of identifying as synonymous to usually, ordinary, commonly, ordinary in general, mostly, most of the time, more often than not, and regularly. All right, so if you're looking at this language, then you go back and you refer to inspection expert in the briefing. And again, brief these things. IXC relied on other cases that provide some instruction to some other case. So RELX Inc. versus Barron, that's a really good case. And we're going to back to that later when we're talking about non-OOH cases. This one was a good one because it says, nowhere in the statute does it require a degree to be solely from one particular academic discipline. This is the one thing where they might say that you can have it from a computer science degree, computer programming, you know, a number of different, you know, STEM-based things, you know, engineering in general, you know, where USCIS said that's too broad, right? It's more than one major, so you can't get it. This is RELX is a really good case to rely on if you have a type of job that pulls from a number of different majors, all right? Make sure that those majors, however, are closely related, okay? So there's still some problems with business administration and broad ones like that, I think. Next case, the first regulatory criterion does not restrict qualifying occupations for those where there exists a single specifically tailored entitled degree program. That's Raj & Co. So again, the same thing there. And importantly, the INFF defines profession, the basis of H-1B regulations, especially occupation require at a categorical level, lawyers and teachers, right? Rather than a tax lawyer or college English professor. Look at that, right? So that means is if you just had any engineering degree, right, you could do a different type of engineering and still be okay. That's what this case says, right? That's a matter of ethics. That's really good. It specifically includes engineers, right? So if you look at these language, they list out some of these professions. It says engineers. It doesn't say computer science engineers, right? So this is really good stuff. It broadens back out where this is. All right. So what if my profession is not in the OOH? We just talked about that, right? So it's very difficult, right? So we really, really suggest, and look, we get into this problem sometimes. Again, if we got an RFE, somebody put it in, they don't think they need a lawyer at the beginning, they put in an RFE, or they do their own LCA, and we got one day to get the whole thing in, and we're stuck with that LCA term, and then we got one of these non-OOH things. Why do people go non-OOH? Well, either one, they don't know really how to look at it, or two, there's a cheaper job, right? And so let's call them something else, right? All right, so you can get there. Now, this case called RELX, which is LexisNexis, they had an F1 student that they want to have a data analyst, right? And data analyst wasn't one of those things. What it wasn't in the OOH, right? The proffered position to be classified into the occupational title of business intelligence analyst, which bears an SOC code of 151199.08, but falls under a more general occupation title of computer occupations all over with 151199. Right, so the USCIS is well aware that because DOL has not amended its LCA to accept 8-digit SOC codes, H-1B petitioners are not able to classify their offer positions using the 8-digit SOC code. You see the 8-digit 1199.08 as opposed to 1199. All right, and must instead utilize more general occupational title being the 6-digit code. Accordingly, in RELX, the petitioner used the SOC code for computer occupations all other, but explains that most specific classification was business intelligence analyst. All right, so they got through this, right? They got denied, they went to a court of appeals and they won, but you can use it in your case, right? This is what you do. This is why we suggest briefing. All right, so level 1 wages are still going to be an issue. We think level 1 wages are going to be a bitter battleground possibly this year. Why do we think that? Because there was a lot of discussion of adding in the ban, the level 1 wages, and there's discussion right now that this could be coming up. So look, I'm no Nostradamus, and I'm not trying to predict it, but we're looking at things. So we know in the last ban that the president asked for the agencies to come back with some new regulations. We think it'll be about the EB2 and EB3, and we think it's going to be about the wages, right? We think there's going to be a large increase of what wages are. So they may say that everybody has to be level 4. They may go to 1 wage for the entire country, which is really going to hurt those industries that don't have the wages that say New York and San Francisco do. We don't know that yet, but we do know that if you're going as level 1, it could be a problem, but it's not fatal. All right, so it just needs to be entry level. So what do we see that are big problems with that? All right, it's an entry level position that requires basic understanding of the occupation. and will entail routine tasks performed under the supervision of superiors. When we see level 1 denials, it's many times because the level 1 person has people underneath them that are in this profession. That can't happen. And you must indicate who's supervising them, right? So in the employment letter, talk about under the supervision of, the senior computer science or computer developer, that this person's going to do this, under a senior attorney, under a senior architect, those sort of things. That's the way to do that. There's a DOL wage chart that talks about these levels. And so look at that, and we use that all the time if we have a level 1 wage. All right, so moving on, I'll try to get through this really quickly so we can have some questions if you have them. But small or underemployed companies, these companies may be tagged by the fraud detection unit. What's a smaller? They look at 3 things, right? They're going to look at how many employees do you have. They're going to look at how much money revenues do you generate, not profit, but revenues is generated. And they're going to look at how long has the company been in place. So new startups are really facing 2 to 3 of these problems, and if they hit the FDU, it goes to an automatic RFE. So what do you do to get around that? Well, you can show media, business plan, investments, contracts. If you have money coming in, show them you have money coming in. Don't be afraid to answer a potential RFE question up front. It can keep you from having an RFE. It can get you approved. All right. If you're trying to work your company out of your house or in a virtual office, don't do it. Don't do it. They will kill you for that. Ownership in a company. Can you own an H-1B? Well, you can. The less you own, the better for that. If it's a big company, you can own stock in Apple, right, and work for Apple. But if you own a lot of it, you can't be an employee, right? This happens in L1 visas all the time too. So if you're an owner, get a board of directors, right? At least 3 of them. Give them equal ability to vote with you, but not equity, right? That's one of the things to do. Have a contract with the board and say that they can hire and fire you, and use the Darden factors. That's a Supreme Court case, Darden versus Nationwide, which is an ERISA case, but it lays out 22 factors that indicate what an employee is. What we do is drop that into employment agreements. All right, special situations with COVID. On this one, under USCIS's own website, this is where you look for that. They have discretion to take the following measures on a case-by-case basis upon request. If you've been affected by the natural catastrophe or other extreme situations, right? That's the language right in there. Natural catastrophes and other extreme situations can sometimes affect the processing of your case. So on extensions and change of status, when applying for an extension or change of status due to a special circumstance prevented you from your planned and timely departure, you may take into consideration how that special situation prevented your departure. If you do not apply that extension or change of status before your authorized period expires, may excuse the delay if it was due to extraordinary circumstances beyond your control. This is where COVID comes in. Many times people couldn't leave because they couldn't even go into their home countries, or they were afraid to, or whatever. And that's in that time, make sure you have some evidence. Make sure that if you're laid off, fired, terminated, that somebody gives you a letter from your employer saying it was because of COVID-19. All right, have that in there. We've seen a couple of people where we've asked them to go back in and do that, or a doctor's note saying they were afraid to go. Anything like that might help. Remember, you might need this down the road when it's hopefully gone and it's not an issue anymore, but they're going to be less sympathetic as time goes on if it's in the rearview window. So make sure that you get a file and keep those things on hand. If you don't know what we're talking about, please contact us. All right, so public charge is now a major thing. It's in the forms. It's in the I-129. All right, so what if you had to get unemployment insurance because you got laid off from your job? Bunch of things with the H-1B right there. Did you file below the prevailing wage? All these sort of things. However, in the language from USCIS, its own site, all right, says if the alien is prevented from working or attending school and must rely on public benefits for the duration of the COVID-19 outbreak and recovery phase, the alien may provide an explanation and relevant supporting documentation. To the extent relevant and credible, USCIS will take all such evidence into consideration in the totality of the alien circumstances. All right. So what that means is if you've been fired or termed or if you have to do unemployment in the past, if you've taken either a state or federal benefit, that would be a public charge, and that would be grounds for denying your case, grounds for deportation. But because of COVID, you have a special situation. So my suggestion is screenshot that stuff that's on the USCIS's website for COVID and put it in there and get a document that says the reason that you were laid off was because of COVID from your employer, and then have the proof that you took these benefits, and then claim that you did, and then show that it was okay under that. All right. So that's really important. Now, if you got a stimulus check, that's not the same as unemployment insurance. Stimulus checks are a benefit. They do not count towards the public charge. You do not need to say you got it, and it doesn't matter. All right. See what else we got. Moving along. All right. Previously approved visas. Okay, so just because your visa was approved before, this is not really new to this year, but we always need to remind it. Back in 2017, so under this administration, there used to be a guidance that said prior approvals need to be given deference, and that's no longer the case. So after they introduce a series of policies with more stringent standards, they're going to apply them to the extensions too. So just because you got approved on a case that may not be a specialty occupation, again, specialty occupation is going to be the fighting grounds right now. We saw it in that memo. Just because you were approved for a QA analyst or an architect or something like that, be careful. Our suggestion is give them a title change, job duty change. You can do that, right? And then go in with the other visa type or other job type. All right. So, our strategy is file all H-1Bs like you've never been filed before. Don't slap a new one in there and say this is no big deal. They get angry about it. You can see it in their RFEs, right? So, as we said, you might change somebody from a computer programmer or an analyst to a developer. Just make sure it's legitimate change, button it up and put them into that job, right? There's the case. Make sure you pay them the prevailing wage. All right, so our shameless plug, Velie Law is powered by OnlineVisas.com. We've developed a disruptive business model to revolutionize the immigration industry. We offer free strategy, not alone in that, but we do it. And so if you go to Online Visas and sign up for it, we'll talk to your company about how you do these things. We'll look at, your cases if you want us to audit it. We'll do all that for free for you if you'd like. Take a look at an RFE or denial and give you some feedback on it. If you're an individual, we can talk to you whether or not we think you meet the standards under your particular visa. We have a 95% approval rating. Why do we have such a high approval rating? Immigration was about 59% on H-1Bs. That's because we answer our RFEs up front. We use a very significant brief that we build out of our online visas portal, right? So these concepts we're talking about, we build into our briefs. We customize it for a particular situation, but we identify early on in our strategy sessions, is this a level 1 wage? Is it a third-party issue? Is it a specialty occupation issue? And then we support these things, right? This isn't secret sauce. It's just longer, harder, more expansive work that goes into than what a lot of cases we see with a 2-page cover letter. We can do those, and we can do it at a very similar price point for those that do a lot less work. So that's what we do. And we're very involved in the documentation of your original documents, right? So we will take a look at what your language say. We may suggest things for employee handbook. We may suggest things for your contracts. We can even give you models for those things. We have 20 plus models of different documents in our system on how we can build these out. Our branding promises are relationships. We know that you can hire anybody. We're there for you. Our knowledge. I've been doing this for 26 years. My team's really, really good and experienced. We believe that the knowledge is continuing to find out these new things and not just relying on how you used to do it. That is a process. And that is a mindset that not everybody shares. Strategy, we think, is key. Strategy is everything here. That's why we want to be involved before the LCA. Don't bring us a case that's halfway done or try to help you fix it if it's already done in the wrong way. It's much better and easier to build it right from the beginning. And process. So not only do we have this briefing process, but we have this technology that we've invented. We have over $1 million in development into it, and we think you'd love it. Anyway, if you're interested in any of those things, please sign up for a strategy session on Online Visas. All right, so how about a few questions if you have any? Looks like we got a couple while we're there. So one question is, what, if anything, should employers be provided from end clients under the ITServe settlement agreement? All right, so this person's saying, what do we need to do? What do we need to do what do we need to give you if you're our attorney, I guess, or give the USCIS if we are an attorney? So really, the end client documents are tricky, as we said. There's a lot of end clients bristle about providing documents due to fear of USCIS, the Trump administration. Sometimes the vendors have agreements with the third parties that they won't get them involved in this process. This has been one of the hardest things. Now, so the ITServe is a huge victory that you don't have to do it. Okay, but if you do it and you partially do it, they may nail you on it because they say they'll look at it. So it's really going to be on a case-by-case basis. If your documents are great, we say put them in. If your documents are inconsistent, don't put them in. Try to win it in other parts of the case, right? That's what we'd say. All right, so you can also give it to them in the RFE. So leave it out and wait to see if they do that. Now, we're going to know more as we start seeing the post June 17th adjudication of these things, right? So understand this, immigration is fluid, it is moving. I remember a few years ago when the RFEs came out for the level 1 wage, they didn't, in that memorandum, you may remember this, which came out on March 31st, which is the day before everybody filed their H-1B. So very, very gotcha type deal. Nobody really had time to even to address that. And in it, they were relying on a footnote that dealt with the RFE. So they were talking about, you know, that they were having a new service standard that was going to adjudicate these things. They wanted to make it consistent. And they had noted that computer programmers didn't always have degrees, right? And under that guidance went the RFE piece. Now, prior to that, if you had made it above the prevailing wage, and the LCA said that you had made it, that was it. That's where the only discussion was back in 2017. And then it became if it's level 1 wage and that whole deal. So at the beginning of that, nobody really knew what to deal with it. You know, so we tried all sorts of things, expert opinions. They sometimes said, well, it wasn't really a worthy expert opinion if the expert didn't interview the company and just looked at documentation. So a lot of gotcha. There's going to be more gotcha this year. We'll see how this does. So stay tuned to us. If you are, we have a YouTube videos on this thing. You can go to YouTube and subscribe. Keep your notifications on, and we'll keep updating you on this. We think that the Trump administration is not done in changing immigration. As a matter of fact, just as recently as yesterday, there were some new issues with student visas, devastating to students, that if you do all of your classwork online, you can no longer be in the United States. Even if you're in the U.S., you have to leave, and if you could be put into removal if you don't do that. And they're forcing the universities that if they students change their deal to file new to report it to CVIS, right? So they're coming at it really bad, and that's a tough thing. We just saw that Harvard and Yale have filed lawsuits against USCIS. That I think they'll be successful in that. We'll see. So we got a question: can an H-1B holders receive Schedule K-1? Well, that's an ownership. So yes, and this is going to be a case-by-case basis, right? So it really depends on really kind of how much you owe and how it's structured and whether you can be hired and fired. So on that question, we'd suggest maybe getting in contact with us. Again, drop me an email at john@velielaw, VELIELAW.com, or go to OnlineVisas and set up a strategy session. Say that you came through this this webinar. We'll get you in quick to talk about it, but I really think that's a very detailed question. But yes, technically you can do that. So thanks for that question, and thanks for the other question on the what can be provided. Okay, so we're getting pretty close to the end of our time. We got a couple more minutes. I'll leave it up there. Again, we're going to record this, or we are recording it right now. We're going to run this again. So if you want to see it again, sign up, go to our YouTube channel, subscribe, like it, and share it. If you have comments, please do this. We sent out a lot of the invitations to this, to many of the questions we've gotten from our very popular YouTube show called Voice of Immigration. A lot of people have been onto that. I think we had 10,000 views on one of our things. We had over 15,000 people come to our website. So glad to be a resource for you for information, and glad to help you with your visas if you need some help. So I'm Jon Velie, CEO of OnlineVisas, and we deliver dreams. Thanks a lot.